My name is Alexandra Compere, and I get the pleasure of introducing our debaters this evening. First, we have Professor Christopher Roeder. He is a professor of law and director of the international programs at Florida Coastal School of Law, where he has taught constitutional law, comparative constitutional law, international criminal law, torts, and various other courses in the past 10 years that he's been teaching. He also is a senior research fellow at the University of Witwatersrand. Okay, I'll take it. School of Law in South Africa, and was the Fulbright Scholar there in 2012. He has written extensively on constitutional law, legal theory, dialect, and torts, and the majority of his scholarship focuses on the intersection of these areas of law and their role in democracy. Second, we have Professor Coling. He teaches several courses, including constitutional law, evidence, and military law. He received his JD from the University of Florida College of Law. He retired as Lieutenant Colonel from the United States Air Force Judge Advocates General Court after 21 years of military service. During his career, he litigated both civil and criminal cases before trial and appellate courts. His professional writings have focused on matters of constitutional law and military policy. He also writes a legal column for homeschooling families and is the author of the Chronicles of Zan, a historical fiction trilogy for youth that takes place in the 12th century in England. I would like to introduce you to our debaters. Please.
Thank you. All right, should I start with your speech first?
I don't think you want the better ones first.
All right, we'll save Professor Coling for last. Okay, so basically I've titled my talk, When the Government Should Shut Up, or at least let other people speak, right? I mean, that's the preamble of the Constitution, which is one of the least enforced provisions of the Constitution, one of the most disregarded, although studying common law, you'll have already discovered that most of the text seems to be disregarded, the majority of the opinions that you read. So I'm going to try to make this somewhat fast, but there's a whole lot of stuff, right? And I think hopefully you'll be maybe slightly offended by some of the things I say, and or slightly provoked into thinking maybe a little more deeply about this wonderful Constitution we have during Constitution Week 2015, right? So these are a couple of examples of easy cases. Easy cases of what I think are unconstitutional things, right? I think of these cases, well, one is an actual case before the court, but this is another one that's never going to make it to the court, right? Tennessee moves to make the Holy Bible the official state book, right? So they actually voted on this in Tennessee. The House put it up. There was an actual, proposed amendment because there was some disagreement about whose Bible should be the official Bible. This is how kind of silly it got. Reagan wanted Andrew Jackson Bible, and someone pointed out that Jackson was a Democrat, and that's no good. And so then there was a discussion about whether it should be Elvis Presley or David Crockett's Bible. Right? And so this is an easy case where government should shut up. Right? The government should not be talking about endorsing certain religious text as the official state text. Right? And I think the Supreme Court would agree with that probably unanimously and say that, no, you can't have the Bible as an official text for your state. Because that tells all the other people in your state that don't believe in that Bible or use a different version of that Bible and or worship some other God that they really don't belong in the state of Tennessee. And maybe they don't, right? Maybe they don't. Maybe they should move somewhere else like Mississippi or Florida or something like that. But I think that's an easy case for the Supreme Court to strike that particular law down. Right? The other easy case is the Woolley v. Maynard case, where the court said, the state can't force you to adopt a message that you don't want, right, and carry it on your vehicle. So, the state of New Hampshire cannot require you to have live free or die on your license plate if that offends your own religious beliefs. Right, so that's the state encroaching upon your religious beliefs and requiring you to carry a religious message that you shouldn't have to carry, right? You should not have to walk around with the state's religious or controversial message, or a message that conflicts with your own beliefs. So these are, I think, two easy cases of the state, should dive into religion and have an official state religion, and or force you into adopting some particular view and carrying it around on your car if you disagree with it. Now this sets us up to a big mess of complicated cases, right? And I happen to think that each and every one of these cases on the board are wrong, right? So Marsh was wrong, Rust was wrong, Van Orden v. Perry was wrong, Town of Greece was wrong, Pleasant Grove was wrong, and this is the one that may offend you, Walker v. Texas Division of Sons of the Confederate Veterans was also wrong. Right, that's the more controversial one, right? Perhaps. So maybe you think the other ones will be controversial too, once you discover what they're about. But the purpose of the pictures going left to right are that in some of these earlier cases, there was seen to be a small sort of hole in the wall between the separation of church and state, right? And over time and over cases, that wall, that little hole, has gotten a lot bigger in the separation between church and state, as well as the separation between government speech and private speech has been widened. And so now we have this mixture, this blurring of what's the government's and what's private, and what is religious and what is government. And I think that's bad for government, but I think it's even worse for the private speech. I think it's worse actually for religious speech, if you believe in that, and it's worse for private speech because of this blurring between what is properly governmental and what's properly private, right? And the government's had its cake and eat it too, right? It partly is trading off of private speech, profiting from private speech, but then saying this is public speech, right? And sort of playing off the idea that they're not responsible for it, but partly responsible for it. So they want to control it, but not take responsibility for it. And I think that's very problematic. So I can tell you briefly about what some of these cases were about. Marsh started off with the ability to have prayers in national legislative bodies, right? That moved to recently in Town of Greece to having prayers in front of local city councils, right? And of course the next move is going to be prayers perhaps, and the circuits are split on this, prayers at schools, in school board meetings in particular. Right? And then if you look at the Van Orden to the Pleasant Grove v. Summan cases, that was sort of, monuments and wonderful things on public parks, right, government buildings, and having religious stuff there, right, that the state has, right, the state has these religious things, and the state has said that's part of our speech, right, but it's not so much part of our speech that we're adopting the religious message, we just like the religious monument, but then you get to Pleasant Grove and they say, we want our religious monument that the state has, endorsed, which is the Ten Commandments, right? That's Pleasant Grove, and it's nice to have the Ten Commandments there. But we don't want this other funky thing that these Summan people had that's kind of like the Ten Commandments, but not, right? So the Ten Commandments gets through the nice big gate in the hole of the wall, but when it comes to the Summan guy, he's blocked. He doesn't get through that pretty gate. He stays over on the private side. You keep your silly religious garbage on your side, but on the other side of that wall, in the public park, there's the Ten Commandments, right? Which is great if you believe in the Ten Commandments. Not so great if your religious views are not embodied in that thing on the other side of the wall, right? And a similar thing then, based on that precedent, comes up in Walker v. Division of Sons of the Confederate, Sons of Confederate Veterans, right? And in Walker, And this is much more problematic, maybe, right, because it's a very sensitive topic. But here you got Texas with its license plates, and everybody loves having their license plates. And some license plates get through the wall, right? And some license plates don't. And Texas says, well, the license plates are our speech, right? The license plates are our speech. They're not private speech. So like with the monument, the religious monument, we can decide which things come in, right? We're kind of endorsing the religious monument, but not really endorsing the religious monument. So it's not quite an offense against the establishment of religion, but it's not private speech either. It's not somebody else's speech. So we're not running afoul of our, violating neutrality and viewpoint discrimination because it's our speech, even though it's kind of your speech, right? And I got some other PowerPoints, right? So that's a bigger picture of Pleasant Grove, which has the 10 Commandments in the park, but they wouldn't let the other thing in the park, right? And part of my argument is you shouldn't have the 10 Commandments in the park, right? The government shouldn't be speaking about the 10 Commandments. Because once you start speaking about the 10 Commandments as the government, and other people with other religious views want to put their stuff in the park, and you say no to their religious monuments and yes to your religious monuments, you send a signal to everybody else that we endorse this, even though we don't really endorse it, we just like the monument, someone gave it to us, right? But we're not endorsing this other thing, right? And the court upheld this in the Pleasant Grove case. They said, you don't have to take that other monument. And that set us up for some other things, right? And this is a PowerPoint in some ways about, another forum, right? The forum of, National Assembly or a state legislative body and or city council, right? And the court has gone from saying, okay, you can have prayers before, a state legislative body because it's largely the state legislators talking together and kind of praying themselves. It's not really open to the public. It's not praying with the public. It's just them saying their own prayer for themselves before their meeting. To now, in the city of Greece, now the city council gets to have prayers in their meetings. And if you go to Jacksonville, to the city council meetings, this gentleman says almost all the prayers. He happens to be a Christian and a wonderful human being. But the Free Thought Society can't do a prayer in front of the City Council of Jacksonville because they're not Christian. And or they're not religious enough. They don't count, right? And of course, there's similar debates in the military with chaplains. And there's a move to try to get atheist and or humanist chaplains in the military for those military people serving who don't necessarily believe in a Christian God or a Muslim God or another type of God that has a chaplain. They want a chaplain for people who, maybe you're spiritual, maybe you want to talk about big things in the world, but there's resistance to opening up for this other group of people, right? And so the problem in any of these cases where you open the door to embracing one set of controversial groups or controversial views into government-type speech, but exclude others within that community all of a sudden feel like second-class citizens. They're not respected as equal Americans, and so on. And so, this is another example, and it's slightly off point, but you also skid it in the same case, Walker, right? The government saying that, hey, you know what, we're going to fund clinics where people can go and talk to doctors and get advice, but when you go talk to those doctors about your family planning, they can only advise you on certain types of family planning. They can't talk to you about the possibility of a termination of a pregnancy, even if that's what the doctor feels would be in your best interest to talk about, right? So in Russ v. Sullivan, the court upheld the ability of government, when it's paying money to say what it wants to say, to determine the message and to decide that if it's paying doctors and funding them in clinics, that it can tell them what they can say and what they can't say to their patients. And again, I think that's another case, right, where the Walker court says, well, that's okay, right? And because that's okay, what we're doing in this license plate case that I'll talk about a little more briefly in a minute is also okay, right? But again, you have this mixture. Someone going into the clinic doesn't know they're going into a government propaganda office that's only going to give them literature about how to exercise their right to choose in only one direction, right? They actually think that they're talking to a medical professional that's going to talk to them about medical advice, right? And they're not necessarily going to get medical advice from that doctor. They're going to get advice that's based on what the government has decided that doctor can say, right? And I think that's problematic, right? And so then we get to this. And this is an awkward case for me because usually I would agree with the 5 people, or at least 4 of the 5 people, that were part of the majority opinion in this case. So the majority in the case of Walker, the Sons of the Confederates, whatever, the majority decided that Texas was well within its right to tell them they could not put the Confederate flag on the Texas license plate. Now, I agree that's a great thing, that no one should have the Confederate flag on their license plate, on their car, on their body, in this country. I think if you want the Confederate flag on your anything, you should move to Mexico. Personal view, right? But when it comes to the government, I think there's a problem, right? And the problem is that Texas has basically opened up this forum for anybody in the world to put almost anything on their license plates. So Texas has the Buffalo Soldiers on their license plates. Texas has Choose Life. Texas doesn't have Choose Choice. But it does have a lot of other weird ones like Oklahoma State. You can actually get Oklahoma State's, official mascot on the Texas license plate, right? Now some states, I'll tell you this too, some states will not let you put Choose Life on your license plate. For the same reason that Texas says you can't put the Confederate flag on your license plate. Because it's controversial, right? Oklahoma State's not controversial, but the Confederate flag is controversial, and in New York State, you can't get Choose Life on your license plate because it's controversial, right? And the problem is the state of Texas and all these other states that have these wonderful license plates are taking all sorts of money in from people. They're picking and choosing based on content of what license plates they want to give out and whose message is okay and whose message is not on these license plates. And then it's turning around and saying, well, this is government speech, right? It's government speech, not private speech. We're not entering into the fray and tilting the conversation one way or another when it comes to, a forum that has private speech in it. We're putting out our own message, and our own message is Oklahoma State, right? So the dissent points out this is ridiculous. What these are miniature billboards. These are miniature billboards that the state is renting out, and it is choosing the content that goes on those billboards, that private speech, based on the message, right? And of course, you may feel very good about them excluding the Sons of the Confederate Veterans, or you may not, right? But you might feel less comfortable about them choosing to not put your Choose Life message on there, or your Choose Choice message on there. But they can choose to put one or the other on there and not the other based on the court's decision in this case, right? And so for the dissent, the point is, this is not government speech. This is not speech where the government is labeled. This is us speaking, right? This is our message. What they're doing is they're mixing their message with private people's messages and endorsing one or the other, and that corrupts, I think, both. So that's the gist of my talk, I think, right? And these are some of the reasons why I think these things should be separated, right? When the government's giving its message, it should give its message, right? It should endorse whatever it's on its license plate if that's what it wants to do, right? This is the Texas Longhorn State. This is the Texas whatever state, right? And if it's endorsing that message, great, and it's saying this is our message. But once it opens it up and takes money from the public to put their own messages on there, then I don't think it can put its fingers on or thumbs on one side of the debate or the other. Because I think then you denigrate some citizens and their messages, and you uplift others, you turn some people into second-class citizens, like the Sons of the Confederate flag, right? And the point about the Buffalo Soldiers is also somewhat controversial, but Native Americans said, look, we were slaughtered by the Buffalo Soldiers. We don't want to see the Buffalo Soldiers license plates on there, right? So everybody's got a problem with somebody's license plate. And the question is it the government's or is it private individuals? So I think government should stay out of telling you what your religion should be, telling you who your God should be, telling you whether Elvis Presley's Bible should be your Bible, or whether it should be Davy Crockett's, or Andrew Jackson's, or King James's, or Tony's, even better. Right? It's probably marked up. Some notes in it on how to be a better person. Right? So that's the point of my speech. And Tony Lee will get up and give a better one, but I think he'll agree with everything I've said. Because I'm right.
All right. Let's see if this other mic works here for a minute. Let's charge it.
No, that's not like from the other room. It actually.
No. Oh, it's not. It's a mic from this room. We're technologically challenged, but I can't really stand behind this thing, so I'm gonna just have to project a little bit. I'm pretty sure you guys can hear me. I'm pretty loud. So I want to talk about this little thing we call democracy. So we all, you're all laughing. Why would you want to talk about democracy? Because we're talking about government speech, and I don't necessarily disagree with some of what Professor Roeder said, especially near the end. But I think we have to start with the premise that we're a democracy. We're supposed to rule ourselves. And we're supposed to elect our leaders, and they're supposed to make decisions for us, and if we don't like them, we throw them out of office, theoretically, and find somebody who will make decisions that we do like. And the Constitution, the United States Constitution, takes into account that we're a democracy. It's not a constitution for a dictatorship or anything of the sort. And so what it's supposed to do primarily is set up structures of power. You guys are learning in your con law classes about the separation of powers and about the split of federal power from state power and how power is bad and how the founders wanted to split up government power as much as possible so to avoid tyranny. So if we can agree on something like that, then let's move the conversation forward a little bit. So what are we actually talking about today? We're talking about the First Amendment to the Constitution. The First Amendment and the Bill of Rights passed right after the Constitution was passed. And one part of the First Amendment says, the First Amendment, Congress shall make no law prohibiting the freedom of speech. So that's pretty much the thing we're focused on here. And the question is, all right, well, what was that intended to do? Was that intended to stop the government from being able to speak on its own behalf? Was that supposed to stop Congress, and then eventually was incorporated against the states later on through the 14th Amendment? But was that supposed to stop government from speaking on its own behalf, or was it supposed to stop government from censoring us and from abridging our freedom of speech? And then, of course, the question becomes, well, what is the freedom of speech? Is it referring to everything? Are you allowed to stand up and yell, there's a bomb, and make us all trample ourselves on the way out of the room? Is that part of your free speech? So that's the kind of fun stuff we cover in con law, too. So I guess the first question is it okay for us to say that the government is allowed to speak about any topic? And I think, if we think about it, and I think we agree on this, from what I heard Professor Roeder saying, yes, it's okay for the government to have speech. That's not what the First Amendment is about. It's not Congress shall not speak, it's Congress shall not abridge our freedom of speech. Because what would happen if the government was not allowed to speak on any subject, especially on any subject that was controversial? So in the Walker decision about the license plates in Texas, the Supreme Court used the example, imagine if the government had a recycling program and they wanted you to recycle your items in your neighborhood because they think it's good for the environment or something. Imagine if the government was not allowed to make that message, put that message forward because there were some people who objected. Maybe there's trash haulers or some union, the garbage folks who are going to be harmed by that. So they want their message to get out with the government's pro-recycling message. Let's also put out a pro-trash message. Throw out all your stuff. That way we'll have more stuff for us to clean up and less for the recycling folks. obviously government cannot operate if everything that government says has to come out, every view has to be taken and spoken by the government. That just can't happen. So I think we have to agree, and I think we do agree, give me a nod if you agree, a little bit, that government is okay to speak on its own behalf. Now where it's going to become an issue is, Professor Roeder might not like some of the things that government's going to say, and I might not like some other things government's going to say, and we might disagree about the things that we think government is saying, but is this a constitutional issue that the Supreme Court, for instance, should tell us, what the government can and cannot say on particular issues? Maybe it is. So let's look at a few things, if I can get this slide to go. So the Confederate license plate. Actually, I'm in total lockstep with Professor Roeder on this issue. The majority opinion in, which was basically the 4 liberal justices and, was it Kennedy? So the 5 liberal justices. No, Kennedy is kind of on the fence. He goes back. They ultimately said this was government speech, that Texas was making these license plates their own speech to people. And as Professor Roeder pointed out, and as Justice Alito for the 4 dissenters in that case pointed out, that's kind of ridiculous. They set it up so every private citizen, who's from Texas? Somebody's from Texas here. Did you design your own license plate in Texas?
I didn't.
You could have, though, if you wanted to, right? You could have put whatever you want on there and sent it in. You see all sorts of stuff in Texas on their license plates. And then they said you can't do this one. But that's because it's public speech, not private. And Justice Alito points out, that's ridiculous because the government can't be saying Oklahoma State and Texas Longhorns and cheering for both teams. That's just silly. So I think we both agree with the 4 conservative justices on the Walker case. So he had to admit that. Because basically, what is the concern here? That Texas was taking what was supposedly government speech, but actually was private speech, and picking and choosing what the private citizens of Texas are allowed to display to the public in their little billboards on their car. And so the reason I agree with Professor Roeder and with the dissent in this case is because I just think Texas was being disingenuous about whether this really was government speech or not. So let's move on from there to some things that we might not agree on. Professor Roeder talked about the religious monuments case. And actually, there was 1 or 2 things I wrote down here I wanted to make sure I remember that you said. Because they're so true. For instance, all right, so Professor Roeder was talking about really not so much freedom of speech, but freedom of religion, and not even that, the Establishment Clause, that Congress will not establish a religion for the national government. So we are going to definitely disagree about this, because I know we have very different views about the parameters of the Establishment Clause, which isn't really a free speech issue at all, but it sort of kind of gets mucked up here in this issue. For instance, Professor Roeder said, the hole in the wall keeps getting bigger to let in, I guess, religious speech into government speech.
And other garbage.
And other garbage. Religious and other garbage into government speech. And I think when I heard you say that, I thought, well, wait a minute, that can't possibly be true. Because when I think about the founding of the nation, going all the way through history up until like the 1960s, I'd have to say that the court was much more willing to let religious speech go through back in those days. In fact, you can read Supreme Court decisions where they say things like, we are a Christian nation. I mean, this is coming right out of the Supreme Court's mouth. The polygamy issue in Utah was clearly the government speaking against Mormonism. They didn't like the Mormon religion and what the Mormons were doing. And the Supreme Court's like, yes, but we're a Christian nation. So the Supreme Court actually was pretty, there was no real huge wall back then. The wall starts really getting erected theoretically in the end of the 1940s, but really it's in the 1960s that this wall gets erected. So I don't think the wall's been getting, smaller and the hole's been getting larger. I actually come from the opposite view. I think they keep building the wall higher and higher when it wasn't meant to be there at all. Maybe it was meant to be a little picket fence at one point to stop the government from actually establishing a religion, and the Supreme Court's taken that concept and ran with it to the point where you'll learn about some ridiculous cases such as, if you put up, there's like a menorah, a Christmas tree, a crash at Christmas, the nativity scene, where the Supreme Court, these 9 justices are basically the ones saying, Well, let me see. Is your display diluted enough? You know, okay, you got the menorah there, but it's a little prominent. We're afraid that maybe you're promoting Judaism. We don't want to send any messages. But there's a Christmas tree, so maybe it's not just Judaism. But so it's like you've got these justices having to pick apart every little display that just the local town wanted to put up because it was Christmas or because it was Hanukkah, because they want to recognize that a large portion, if not the overwhelming portion of their population, is celebrating a holiday that, you know, is an ancient holiday. And in fact, the court is going to tell them, no, you can't do that, that's bad. You're trying to make people feel like second-hand citizens, and instead, we're going to shut you out and not allow you to acknowledge what, you know, 100 years ago, the Bible wasn't just the official book of Tennessee, it was the textbook of all public schools in the nation. So, I mean, it's come a long way from that, right? And I'm not suggesting that we go back necessarily to that. I'm just saying things have changed a lot, and it's not that the hole's been getting wider, it's that the wall has been getting higher, actually. So, bringing us back to government speech, he talked about the Summum case, where basically they had been given this Ten Commandments monument by some private group. It was in this little town's park. The Ten Commandments are not just something that the government came up with, right? This is something that is foundational in Western civilization, the basis for a lot of the moral codes of Western civilization. It has a historic place, whereas this Summum thing was something that was made up fairly recently, and I think was really, we have several groups, right, that their point is they want to get rid of the Ten Commandments and other things that are up. So they'll push government, right? Hey, you're going to put the Ten Commandments up. Let's put my satanic display up too, next to the Ten Commandments. You know, and kind of force government legislators to have to get in this really uncomfortable position where they're like, well, then I guess we can't have the Ten Commandments up either, because now we'll have to display Satanism next to it, and we don't want to do that. And Professor Oder's point is a good one, which is, you know, we don't want government picking and choosing religions over each other, making people feel like they're second-class citizens. That's great. But when they had a historical reason, not to promote religion necessarily, not to promote Christianity or Judaism particularly, but simply to recognize a major historical document of Western civilization, you know, and they're not going to be allowed to do that. Even the Supreme Court hasn't gone that far. The Supreme Court said it was okay. Now, there's some cases where the Supreme Court has said the Ten Commandments aren't okay, but sometimes it is, sometimes it's not. It's the crazy way the court has come up with the wall. The point is, if the government said, hey, look, this is our park, we were given this thing a long time ago, it has to do with the history of our nation, whereas this other thing was just given to us the other day, it has nothing to do with our heritage, why should we have to put it up in our park? That's not our heritage. We don't want to have to display that, because then if we display that, everything somebody gives us, we're going to have to fill our park with. So should the government be able to say, look, we have a reason for the Ten Commandments. It has to do with our heritage. It has to do with, you know, many other things. We don't have a real reason to put this other monument up. So no thank you, appreciate the offer, but we're not going to put it up. I would say yes, the government should be allowed to do that. The Supreme Court ruled in this case, what was the ruling on this? 9-0, actually. Even the liberal justices agreed that Pleasant Valley, or whatever they were, Pleasant Grove shouldn't have to put up the Summum one. So this isn't a really controversial one. What about chaplains? I'm a military guy, so we have chaplains. Are chaplains constitutional? Is it okay for us to use the taxpayers' dollars to pay chaplains? Here's this guy, he must be Catholic or something. It looks like he's giving somebody communion. So is that okay? Here's the first Congress, you know, praying. Here's President Obama praying. So is it okay for government to acknowledge God, to pray before they have a meeting? Is it okay for the military to have chaplains who can cater to the religious needs of the people in the military? The Supreme Court has never actually had a chaplain case for the military. The Second Circuit decided a case back in the 1980s where they said it was okay, and they primarily used the argument that because those of you who've been in the military, you know, they could deploy you all over the world against your will, And if you have a religion that you're practicing, you might be stuck somewhere where you can't practice. So they almost saw it as an accommodation to religious people. Let's have chaplains there so they can cater to these religious people that we're sending to East Jabit to fight a war or something. But the legislative prayer cases that Professor Roeder was talking about, the Supreme Court has said now consistently it's okay if our legislators pray. Heck, they should probably pray more. Maybe we won't get some of the crazy things they pass. Or perhaps we'll get we might even get crazier things, right? Maybe that's maybe the problem is they haven't prayed, right? But the point is, if they want to pray before their meeting, okay. I mean, it brings together this idea of, they're not just there on their own. They're serving the people. They're serving a higher power. Oh my gosh, I guess we have to get rid of the Declaration of Independence, because that says all of our rights are derived from our Creator. And we don't want to make people who weren't created feel like second-class citizens. So we shouldn't let that happen. I mean, it gets ridiculous. So at some point, government should be able to give a certain message on some things. And yes, there's a limit to where that is, but clearly even President Obama doesn't think a limit is not allowing him to pray as the president. What about the final topic? I think this is the final topic. The issue of giving out information on procedures such as abortion. So here's a situation where the government is saying, look, this is something we think women should be told when they come in for a consultation as to whether they should get an abortion or something. And so what I've got up here on display, just so you know what you're looking at, this is a 4D ultrasound image within the womb of a baby sucking its toe and putting its hand up to its face. And this is an embryo in the sac, what do you call that? Placental sac, in somebody's palm of their hand. And that's the sign that says women deserve the truth. So the Supreme Court acknowledged in the Planned Parenthood versus Casey case back in the early 1990s that it's okay for government to take a side on the choose life issue. We live in a democracy, right? If a majority of the people want to encourage women to choose life, that's an okay position. The Supreme Court said that's perfectly fine. Government has to sometimes pick sides. And I mean, what would be the other option for them? You said choose choice, but that's not actually the opposite of choose life. They would have to put on their license plate, what, choose abortion, choose death? I'm not sure what they'd say. They wouldn't say choose choice, because that's different. But it's okay for government to promote life, is what the Supreme Court said. Now, all right, fine. So if you go for a procedure and the government says, hey, informed consent, we want you to take an ultrasound. That's laws that are being passed right now. Some states are saying, we want you to take an ultrasound before you make this decision. You read some of the Supreme Court decisions, they talk about how sensitive an issue this is and that some women might actually deeply regret an abortion later. And wouldn't it be better for them to have more time to think about this before they make the decision? Are we going to say that the government is unreasonable for wanting to give people more time or more information? Now there's always going to be controversy. Well, how much information? What information? Are we going to say you can't say this or that? And then there are going to be controversial things, because think about everything that the government regulates. It's not just abortion procedures that you have to give informed consent on. The government regulators regulate a whole host of things. Go sell an insurance policy. Go sell a house. Look at all the things you have to be told by the government to disclose. Is it okay for the government to not necessarily say that themselves, but to force you to say that in certain contexts? Apparently it is. It happens all the time. So this really isn't all that unusual. This is just on a much more controversial topic than most. So I guess to just sum up and then finish up, and then I guess we'll do a few minutes rebuttal if you'd like, and then see what kinds of questions you guys have. I guess my point mainly is, yes, there needs to be a limit to what government can say, but we also have to recognize it's okay for government to speak. The First Amendment doesn't stop the government from speaking. It's okay for the government to make reasonable choices on the things they're going to say. And in a democracy, the check, if we don't like it, if we don't want our government telling us to choose life, if we want the government to tell us to choose abortion or to choose the death penalty or choose something else, then just vote in the people who are going to make that statement for you. It's not a constitutional issue. We don't want, like, the Supreme Court for all time telling us in a democracy what you can and cannot say. I'd rather wait and say, okay, well, my views, I want to get in the majority eventually, and then we'll change the government's message. They won't do this anymore. They'll tell, women whatever, my elected representatives tell them to tell them. I don't know. We live in a democracy. That's the point, right? And so the Constitution has its place. So having said that, it is time for your rebuttal.
Yeah, I have 2 points on rebuttal.
So only the moot court people
2
got
points
that.
on
It's clear there's nobody from the court.
So the first point's a little bit complicated, right? In some ways, the wall, there was talk about the wall separating church and state all the way back at the beginning. Of course, it was controversial back then, and there wasn't a clear wall. And like you say, up until the 60s, there wasn't much of a wall there, right? But what changed in part was a civil war and a new constitution, right? A new constitution happened after that Civil War, bringing in equal protection. And so the Equal Protection Clause changes, I think, a lot of the dynamic between, or it informs or should inform the way we look at the religion clauses. And the religion clauses are part of the First Amendment, right? And it relates to that government speech, right? That the government shouldn't be establishing a religion, right? And of course, establishing a religion takes you a long way down the road, you might say, long past having a menorah in front of the courthouse. But the Equal Protection Clause for a number of justices should inform that notion of, of religious freedom and the Establishment Clause, such that nobody should be a second-class religious citizen, right? The Mormons, for most of our history, were second-class citizens of the United States. And you admitted it, right? That basically that case, they're endorsing.
I would never say more than second-class
we're
citizens. This is on tape. Are you crazy?
Historically, right? Before
Catholics have been second-class citizens
Catholics
in the United
were
States
second.
since the founding, though. I can say that as a Catholic.
that is true.
And we still are. Thank you.
And so, but we shouldn't be, right? We should be respected like everybody else. So second point, and that goes to the, it's interesting because we chose different, we talked about, we were going to talk about abortion and information about abortion stuff, and we picked different cases. But I think both of those cases together kind of tell you what's wrong with the government getting involved in that. In the one case, in the Russ v. Sullivan case, they're telling doctors you can't give women this information. You can't talk to them about this information about this side of a choice, right? And then in Casey, they say, but you can, based on the notion that women should be fully informed, give them all sorts of information about how they're going to regret this forever, and look at the sonogram and look how horrible your life's going to be if you make this other choice. And that's where I think it's problematic, when the government comes down so decidedly on a person's right to choose and think about the right answer to very difficult moral problems. And I think they are deeply religious and moral for people when they're deciding these kind of problems. For the government to come down on one side and put a gag order on your information about one, but then yet, steamroll you with the other and say, no, you can't make that your own choice about that unless you wait 24 hours, take this sonogram, get all this extra information about how you're going to regret this, right? But not give you the other side of the information. I think that, for me, is the problem. So I think that's where the government speech, again, offends that equality provision. And I think the problem with religion, abortion, a number of these issues, once the government enters into it, then you got a thorny problem. Then you got this, how close is the menorah to the Christmas tree, and is there Bugs Bunny in there, and the Easter rabbit, and whatever else, right? And so you avoid all that if government just shuts up about some of these topics, unless the people.
So, and I'll just say one thing in response to that. Number one, if you want the government to shut up, that's what we're in a democracy for. Tell them to shut up, and they'll stop talking about that, right? Number two, I think you overstated that information. I'm not so sure that was a super accurate characterization of the information that they were telling women about abortion. You may have just slightly overstated that. and the types of things they would tell them. But you're right about one thing here, I think. That is, it's super controversial, and if it's an area that we really feel like we'd rather the government say nothing about it, I think that is a reasonable position you could take, and that you could take up with, your legislators. But A, it's going to go a lot further than just that one topic, because government forces us to learn information about a lot of things, and I want to open it up for questions. Although we should probably know, if you pick the 3 most controversial topics in the world and then ask students to have to say something in public on tape, maybe we should shut the tape off and then they'll really put off. But yes.
The Supreme Court makes decisions about the displays of the 10 Commandments on different states and counties and what could be posted and not. In the National Archives and at the Supreme Court, the 10 Commandments is on the building itself, so unless we tear down that whole building, they're basically hypocrites. Do you not agree?
What do you think?
Yes, I do not agree. So yeah, I think Professor Cohen would maybe agree, right? And of course it comes up in the opinions, right? Scalia will point out, look, there's Moses and there's the 10 Commandments, but also the difference, and this is why they feel comfortable doing the balancing, because the balancing is there in the Supreme Court. So if you look around the motifs, you've got Moses and you've got a number of other people though. You've got Hammurabi, and you've got a ton of secular stuff and a ton of lawgivers that include Moses and other people, right? You've got a lot more stuff besides the 10 Commandments. You can go all the way around and it's the whole history. And then even inside, you got all sorts of stuff. So, and it's not all religious stuff. It's lots and lots of secular stuff. So they're like, look, no one's going to come and think that, because there are cases where the judge has the 10 Commandments on the wall in the courtroom when you come in, right? And that the court says is different. And so, yeah, it is in some ways a hard balance. I'm happy for them to tear it all down myself.
But we
Right.
talk about the heritage of the United States, and we forget that the Capitol building was the first church, national church, and every Sunday it used to be open for services because it was the largest building to hold a congregation.
Right.
So if we talk about heritage, and we should be able to keep all aspects of our heritage, from the Confederate flag to the church, and basically there's nothing in the Constitution that I can find, and granted I'm only a 2L and haven't taken Con Law 2, but there's nothing that says that I have to protect.
You're not going to find it in there.
There's an equal
I don't have a
protection
right to be, not be offended. There is nothing that guarantees that as a right.
So yeah, let me take two points from what you're making. One is exactly that concern that you're raising, and actually, Professor Roeder, you basically just said it. You'd be glad for them to rip all this stuff down. And I think this is a problem. The problem is there's a purge. There's a purge of the heritage of the nation. So in the name of not making anybody a second-class citizen, we'll basically censor and purge our entire history of anything that we don't like or that we think could be offensive. And it's the government that's going to do the purging. I have a problem with that. But also the Equal Protection Clause thing that you brought up, I don't think that's what the Equal Protection Clause was meant for. I mean, it was passed as one of the Reconstruction Amendments. It was primarily passed because the freed slaves were not being treated equally. And that was the main focus of it. Now, yeah, it's much broader than that. Now, if you just read it, it didn't say just, equality for freed slaves. But that was the main purpose of it. And I'm sure nobody ever would have thought that the Equal Protection Clause was going to be used to somehow make the Supreme Court tear down their building because they had a little picture of Moses up there.
You want to jump in?
Well, I think we keep talking, I understand your point about the equality, and we keep talking about trying not to be second-class citizens, but guess what? Reality is we're born as second-class citizens, being a child to parents. I was in the Air Force for 22 years. I felt like a second-class citizen as an enlisted compared to officers. You get into the officer ranks, and you compare a fighter pilot to a regular officer, they don't feel as great as the trigger puller.
But the JAGs are at the top, right?
Right. Yeah. So even in this scenario here, I imagine 3Ls feel a little bit superior to 1Ls, but they're still going to feel inferior to professors. So there isn't. I guess what I'm saying is there There is no place where you're ever going to feel that you're equal in any situation at all.
I agree.
So what I see as a big debate is, I understand the majority should not snuff out the minority. I fully understand that. But we're going the other way, where the majority is basically being shoved down their throat, the minority beliefs, concerns, whatever. You know, and I think that that's where it's going too far. And you're trying to get, okay, so let somebody have a Confederate flag. I really don't care. But don't come and, you know, and shove that down everybody else's throat. You know, either way. It should be that if you're a minority, like this is a Judeo-Christian country, if you don't feel, you know, that you don't want to subscribe to that, that's fine. You have the right not to do that. But don't force everybody else who is a majority in that sense, you know, to
But we're not a Judeo-Christian country. I mean,
Yes, we are.
our founders, plenty of our founders were not Judeo-Christian. They were not Christians. A number of them were not. Not all of them were Christian. A lot of them, you know,
We're
left
Jews.
persecution. Huh?
How can you not say that we're not Judeo-Christian?
There are plenty of founders who were not Christian.
They don't, I'm not saying that they weren't, but some of them were.
Some of them were, but they
So
didn't
you
put that in
cannot
the
detract from the
Constitution.
ones that
Some
were.
people's constitutions actually have, this is a Christian country. Ours does not. Our
And we have
constitution
Iran
is...
that is an Islamic country, but we never declared ourselves a particular religion. We
Exactly.
have, our founders, some of them were ministers, ordained ministers.
Absolutely.
So
I
you're.
mean, and in fact, the person who did the Pledge of Allegiance was a Baptist, and he didn't put God in it. That was put in later,
And
right?
I do agree, though. I mean, of course, not all the founders were Christians. Some of them were deists. And this was during the Enlightenment era, so some of them were probably atheists. But the point isn't whether particular people were a particular religion or not. The country emerged out of Western civilization, which was a Judeo-Christian, highly influenced by Judeo-Christian values. And that's what formed our legal system, that's what formed...
But the slaves that were brought over, right, they're part of our tradition. They weren't brought over, they weren't Christians. Right? The slaves that were brought over were not Christians. They didn't have a choice about coming to this country. Now, many of them became Christians, right? But they didn't have a choice. They were brought to this country. Now, and part of the end of slavery was the equality provisions, right? And a respect for that tradition too, right? And the respect for all traditions. And so, you know, you can elevate one over the other if you're comfortable with that. You can say, and you can put it in Judeo-Christian, but I can tell you the people in this city who feel most oppressed often are Jews. Because they go to any meeting and people are praying, and they're not praying Jewish stuff. And they run into people and they're asking them what church you go to and what, you know, at their work and at their office and when they go to city council. And so my point is, you know, there are times when this, you know, individual's fine. You pray all you want. Take your own time to pray. Do your own prayer. But if I came into the classroom and said, you know, I'm going to start the class with a prayer, and it's my prayer, and this is not equal, right? You're going to listen to whatever my prayer is. And if you don't believe in my thing, and you want business before my counsel,
But if you did that, nobody is going to shackle you up and throw you off the building. Everybody would just sit there and go, okay, well, it's a little bit different. Okay, we just deal with it. We
okay, I'm
go
going to
on.
switch over to Colin.
All right, so let me, we have some hands up on this side. Let's grab some other questions up here.
From my understanding, the 14th Amendment is more of a good thing, clause, but basically, like you mentioned, it's supposed to be used to, you know, help the minority, but not necessarily make the minority view be, no matter which direction, be permanent for you. I think it's a situation where, like the nativity scenes, every single year we've, you know, there's a story, mostly because of Fox, that says, you know, there's a problem with the nativity scene, and in my opinion, you have a lot of people who want to troll these scenes by asking the city councils to prop up their own particular, for instance, the Satanic temple statute in Detroit. And for me, I feel like the 14th Amendment is being abused in those situations because these are situations where 99% of the time it never happened, but these people just want to basically troll a particular, you know, group. And I feel like Do you not feel like that?
Yeah, I mean, to be honest with you,
that way?
when it comes to the nativity scenes and the stuff on big parks, I really think most of that's silly, right? To be honest, I think it's silly. It's like petty. It's like, what's the big deal? Where I have a problem is if you're going to go into a courtroom and the judge has the 10 Commandments in the courtroom, and that's a judge. Or you go into before a city council and everybody's praying in city council, you better have your head down, right? If you got business before the city council, you better be praying along with. Because if you're not, you got business in front of the city council. And that's where I have a problem, is when it's clearly government. Now, some of the park things, I mean, hey, I gave trouble about the one park and then they exclude the other one. But that's what, the summon case is what set up the Texas case, right? That was the case that they used to justify censoring the license plates, right? Because everybody agreed in the summon case, they could exclude the other monument. They said, well, same thing when it comes to license plates. And that
Just
was
to
the
be
problem.
clear, I mean, there clearly are limits in the Establishment Clause to what government can and cannot do with religion. And if in fact the situation is the city council is going to take negative action against a citizen and treat them unfairly because they didn't bow their head to pray, I'm pretty sure Justice Scalia, Justice Thomas, and every other conservative justice would find an Establishment Clause violation because basically that's using religion to coerce. But that's not actually the reality. I mean, that's kind of like the straw man that we trump up. And if it is the reality in some places, then that should be stamped out, because that's wrong. But you don't throw out, as my mom used to say, the baby with the bathwater, right? And that's maybe my concern and Mr. Robinson's concern, which I would agree with what he said. Yes?
I don't know if anybody, I'm sure plenty of people watched the debate last night on
Is there a debate?
And
Was it Hillary and Biden?
yeah. So it was one of the, I guess, lesser mentioned issues. It kind of was worn over, but it's a social issue. Is marriage, and you know, for a long time we had the Defense of Marriage Act, and now it's kind of been repealed. And you know, we have Kim Davis, I think that's her name, in Kentucky. You know, where do you draw the line? Because I mean, you know, we did, like was said, we made accommodations for Gov't detainees. Why couldn't we make an accommodation for her maybe? Because for me as a Catholic, you know, I do believe that marriage is between a man and a woman, but at the same time, I'm not gonna like go out in the street and like hold up like ban gay marriage, because it's not my place to say it. I have my own beliefs, but I feel like that she was kind of discriminated against, and in the view of public, you know, opinion, the media scorned her, and I thought that was wrong. I mean,
The court gave her an accommodation. The court let her go. She doesn't have to marry anybody. She just can't stop people or other people who work for her who's sworn to uphold the Constitution, right? These are state officials. This isn't a private person deciding whether to marry somebody, right?
Hold on a second. Just
Right?
can I?
She's a state.
The accommodation was putting her in jail
yeah.
until she agreed to shut up.
She never agreed. No, they let her out without her agreeing. They let her out because her clerks were marrying people, and they let her out and they said, well, we're going to let you out because your clerks are marrying people, but you're not allowed to stop them from marrying people.
Well, I guess my question is like, why was she thrown in jail in the first place?
Because she said she stopped them from marrying people.
Right. Yeah.
Right? So she stopped her clerks from marrying people who had a legal right to marry under the Constitution.
Right.
And she's a state official, and she is directing other state officials to violate the Constitution. And so then they put her in jail because she violated the court's order. But the court, once her clerks were marrying people, they said, you can get out. You don't have to marry people, right? If your conscience says that, but you cannot stop other officials from carrying out their constitutional duties. Otherwise, we'll put you back in jail.
That's where I think like there is like almost no division right there between church and state. It's like, I got to go to the courthouse to get my marriage license, right? And now, you know, before gay people can get it, but now they can. And I just, like, why is the government even involved in that issue? And like, why is it that when a priest at a Catholic church, you know, a gay couple comes up and says, we want you to marry us, he says no, and then like it becomes this huge issue like, oh yeah, like he has to marry them, you know, it's the law. It's like, well, he has his own law.
Recognize we've got civil marriage and then we've got religious marriage, and sacramental marriage, And in some countries, like we were in France over the summer, and the professor in France was telling me that unlike the United States, where ministers have been deputized by the government to also be able to issue civil marriage, conduct civil marriage ceremonies, in France it's not like that apparently. And even if you get married at the church, you have to go to City Hall. Whereas in this country at this point, certain, if you get the proper certifications or whatever, you can do the marriage. But what you're asking basically is, why don't we separate it like France does, so that we don't have this issue? And some other people are asking that same question. And who knows? Maybe this issue will drive us to separate it like that. But no, I mean it's a good question. It's a tough question. And I'm wondering if there's any other questions out here.
There's one back there, and maybe he changed his mind.
I was just going to say the whole issue there is finally they did accommodation for her that they should have done before they put her in jail, because they took her name off the certificate, so the deputy clerk could not sign it in her name, and that was the crux. So that could have easily been done beforehand. But the governor made an accommodation to change the certificate, but then would not make one to take her name off.
Yeah, I mean, there was a lot of complicated, and they still don't know, I guess, if that's even legal, and who knows, these poor people might have to come back and get another marriage license
But
later.
the point was, they would not accommodate for her Christian beliefs about, and what I think about the ancient Constitution, and they should accommodate it. The other thing is, I think personally that was all done to force it up to a higher level to get it back to the Supreme Court. So she got used by both sides. So.
And that happens all the time, right? As far as trying to trump up cases so that we can deal with issues. Both sides do that on a whole variety of issues. I'm assuming we agree on that. Was there a hand back there? Other questions, especially on government speech specific? If not, thank you guys for coming out. I hope you enjoyed the